We continue reading the case of Fiona Alfred versus Maria Alfred, heard in the Supreme Court between 2021 and 2022. It was a case under the Property Rights of Spouses Act. It is the claimant's case that she had an agreement, that the claimant, Mrs. Alfred's case, that she had an agreement with Mr. Alfred that he would take care of the financial responsibilities in Jamaica. She would work and use the money earned to take care of the financial side in the USA to pave the way for the accommodation of the children and later Mr. Alfred. So she said she was preparing to pave the way for the children and Mr. Alfred to go over there and join her. She had discussion with Mr. Alfred and it was agreed that he would rent a portion of the house and the funds earned would be put towards the payment of the mortgage and maintenance of the premises. It should be noted that Mrs. Alfred initially asserted that they decided to share the rental proceed equally, but she received none. So she was saying that Mr. Alfred was taking all of the rent money. Well, in her later affidavits and after being pressed in cross-examination, she changed her evidence and stated that the rent was to pay the loan and maintain the premises. So you see how difficult, how emotionally stressing a divorce case can be. They have to be going back through all of these agreements and what they said and what would be done and, all of these things that they have to be coming up with. One, Mr. Alfred's lawyer, cross-examining Mrs. Alfred, all sorts of cross-examination. Oh, but anyway, we see that a lot of detail in terms of records, financial records, what was said, what was decided would be presented in court. Let's continue. The claimant, as Mrs. Alfred, stated that she had used her own money to purchase household furniture, pay utility bills, and take care of the children after they migrated to live with her. She bore sole responsibility for the rent for the house in which she lived with the children in the USA, as the children migrated at short notice at the insistence of the defendant, Mr. Alfred. So he's saying Mr. Alfred was the one who insisted that the children leave and go and join her. And she had to relocate from her mother's house to accommodate them adequately. Hold on, at the insistence of it, and she had to relocate from her mother's house, that was back in Jamaica, to accommodate them adequately. Well, she also sent money to Jamaica to invest, but lost it in the Olin scheme. She worked as a team with the defendant, Mr. Alfred. So that's saying that both husband and wife worked as a team and they shared responsibility as a couple. She relied on the defendant, Mr. Alfred, to handle their affairs. She, however, disagrees that the loan that the defendant had obtained from his mother is related to her, as she deemed it a transaction between him and his mother. So she's saying that Mr. Alfred borrowed money from his mother, but it wasn't her, Mrs. Alfred, that the money was going to be used to benefit. You see, all of these details, these family negotiation, loans, and so on, which would otherwise have been private. Because they're now in the courts, they are public records, right? But it shows the difficulties that two once couple in love are going through now, fighting each other over money and property in the divorce. But that's a reality. But what this shows is that if you find yourself in a similar situation where you and your spouse are going to divorce, then all of these information would have to be presented to the judge. All right? The claimant, that's Mrs. Alfred, contended that she maintained her interest in the property and had never abandoned it. So it seems as if Mr. Alfred was saying that his wife abandoned the property, so she doesn't have any interest in it. But Mrs. Alfred now is saying, no, I did not abandon the property, so I should get something. She had constant communication about the matrimonial home with the defendant, that's with Mr. Alfred, and was updated. She also knew of the change of the loan to the Bank of Nova Scotia for a lower interest rate, and that the previous loan was discharged in 2010. She spoke of discussions she had with the defendant as he would keep her informed about the tenants and issues regarding the property. So she's saying that she still had an interest in the property. She didn't abandon it because she spoke with Mr. Alfred and he told her about the tenants and issues with them regarding the property. An email sent to Mrs. Alfred by Mr. Alfred dated November 18, 2013 about a problematic tenant was further proof of their discussions. So you see, when it comes to communication between you and your spouse, especially if the marriage starts to become difficult, you have to maintain records of these things because you might have to present them in court later on. Another email dated January 3, 2019 concerning the application for a replacement title was also admitted into evidence. Furthermore, she stated that over the years, whenever she returned to Jamaica, she would visit the premises. She visited the property after her father's passing in 2007 and later in 2008 and 2012 when she prepared the property for incoming tenants. So you have a gap of 4 years there. All right. The defendant, Mr. Alfred asserted that after they were married, Mrs. Alfred made the unilateral decision to change her job and relocate to Montego Bay with the children. He said he visited them at the rented premises at Westgate Hills on the weekends, but did not live there with them. He also stated that Mrs. Alfred again unilaterally decided to resign her job and migrate to the USA, thereby abandoning her family and the house they bought together. So he's saying that she took it upon herself without him agreeing to go overseas and thereby abandon the house. So she's saying, no, she didn't abandon the house, and he's insisting, yes, she abandoned the house. He said the property at Bow was never purchased as a family home, but rather as an investment for himself. He defined investment property in cross-examination as something you buy into. He insisted that there was no discussion between Mrs. Alfred and himself about the property becoming the matrimonial home. He further elaborated that there was no agreement indicating our intention that the property was matrimonial property, but was to honor our obligations jointly. He said that the matrimonial home was in New Jersey, USA, purchased in 2012. So this house that they bought, well, it seems as if the lesson here is that it should be clear, if you buy a house, if you and your spouse, or you buy a house, you alone buy the house, you should have a record, put it in writing that this house is not matrimonial home. It is an investment. He didn't do that. But maybe the house was indeed matrimonial, but they didn't really give concern to that until the divorce came up. Because if it was matrimonial home, then the court could order that it be sold and the proceeds divided among the two of them. So it's very important whether that house is the matrimonial home or not. We continue. Mr. Alfred, the defendant, asserted that Mrs. Alfred abandoned her family in July 2007 when she left for the USA, leaving him with 2 children and all the financial obligations. Mrs. Alfred only lived in the house for approximately 1.5 years before moving to the USA. She left without telling him of her plans, nor did she communicate with the family for some time after moving. He had to demand that she get the children into school by September 2008 and that she filed for his immigration petition. You see how bitter a divorce can be. Mr. Alfred is the defendant. Remember, the claimant, is the one who filed who is filing the papers, and the defendant is defending himself. That's Mr. Alfred. So here is Mrs. Alfred who files for divorce, and Mr. Alfred is the defendant. Mr. Alfred further declared that after Mrs. Alfred's abandonment, so he's saying after his wife abandoned him, the children, and the home, he was left with servicing the loan for the house until January 2016. He did not advise her of securing a Bank of Nova Scotia loan after the initial mortgage was discharged. He later conceded during cross-examination. So her lawyer is questioning him now. He conceded during cross-examination that he informed her that he had obtained a loan during a telephone conversation. Hold on. He said he did not advise her of securing a Bank of Nova Scotia loan. But then her lawyer questioned him now, and he conceded that yes, he had told her that he informed her loan during a telephone conversation. Okay. So here, he pointed out, however, that he alone discharged the loan. So now, Continue. Mr. Alfred, the defendant, asserted that he rented a part of the premises, paid the taxes, and saw to the property's maintenance and improvement since Mrs. Alfred abandoned it. He said that Mrs. Alfred had never asked anything about the premises, and neither did he account to her in any way about anything concerning the property since she abandoned it in 2007. He was never put in charge of renting the property. Instead, he rented the property as he was the only family member left in Jamaica. For that, he incurred several expenses. He further stated that Mrs. Alfred's evidence about the amounts charged for rent was an indication that she knew nothing about the property, as only the original section was rented and it was never rented for $40,000. So you see the stress of this all. He is insisting that Mrs. Alfred abandoned the property. So Mr. Alfred is insisting that his wife abandoned the property, but she now is insisting that she did not abandon the property. Mr. Alfred said she never asked anything about the house. It shows that she abandoned it. Mrs. Alfred is saying no, she had asked him about the house, though she did not abandon it, and it's just back and forth. Now, important decisions like these should be recorded. Alright? Should be recorded. Even before problems start to arise in the marriage. So, you make sure that anything that might be called upon in a divorce case is properly recorded by you. Alright? Make sure you do that. Mr. Alfred gave evidence that he regularly sent monies to Mrs. Alfred to maintain his family overseas. In contrast, Mrs. Alfred, on the contrary, did not send him any funds to assist with taking care of the property. So he sent money to her, but she never sent back any money to him. The defendant declared that expenses in the USA were shared between, that's Mr. Alfred declared that expenses in the USA were shared between both of them, while he was solely responsible for the Jamaican expenses. So you see, he's trying to defend himself here from her claim, because these things are important in the courts. The judge will consider all of these facts. How much money you spent? Did you send any money to take care of the children or the house? These things must be recorded. Alright? Even though both of you are married and it's lovey-dovey and everything, if you end up before a divorce court, then it's no longer lovey-dovey. It's about business. It's about figures. It's about back and forth fighting, and it can be brutal. Now, Mr. Alfred, he testified that in 2012, he had sent US $35,000 to purchase the matrimonial home in New Jersey. Mr. Alfred also contended, even though it says the defendant, I'm saying Mr. Alfred because he is the defendant, Mr. Alfred also contended that even while he lived in the USA, he would visit the property at least twice annually to effect repairs and to ensure the property's safety and security. He could not say the same for Mrs. Alfred. So she did not visit the property to take care of it. He said that since Mrs. Alfred left the premises in August 2007, she had never returned to it. Until the present claim, she has shown no interest in the property, neither contributed, knew nothing about the property, neither visited, nor made inquiries, and made no demands of him to hand over rent. So he's saying that he is the only one who bought the property, maintained it, and now she wants part of it in divorce court. That's what he's saying. Now, Mr. Alfred further stated that Mrs. Alfred had visited Jamaica several times on vacation and on sick leave, but had never volunteered her time to the property nor visited. She had never paid property tax, spent no time cleaning or preparing the house for new tenants, and left no belongings at home. So he's presenting these to show that she had indeed abandoned the property and should not get a share of it. Alright. Mrs. Alfred had sent money, the defendant recalls, US $10,000, but he gave it to her friend and was later told that they lost the money in Olint. Such sums sent were never for the house. Now, Mrs. Alfred also gave evidence that once the claimant, Mrs. Alfred left, this is what Mrs. Oldane Alfred, alright, also gave evidence that once the claimant, that's Mrs. Alfred, left in 2007, she never returned to the property. Or maybe this was a typographical error here. It's Mr. Alfred who would say that once Mrs. Alfred left, she never returned to the property on her several visits to the island. Even when she was in the company of the children would have traveled to the Bogue property with their father, but Mrs. Alfred would not go with them. Mr. Alfred stated that he had been in exclusive occupation of the property since 2007. He alone lived there. He alone occupied the property. He claimed to have used the property as his business office and indicated that he used the property's address as his business address. He said he also changed the locks and gates without Mrs. Alfred's knowledge, and she no longer had any access to the premises. He also changed the locks to ensure that she would not enter or interfere with his tenants or with his exclusive possession. Mr. Alfred said that he sent Mrs. Alfred an email about a problem tenant to inform her of the occurrence. Still, she was not a party to the resolution, and neither did she involve herself in resolving it. So he's saying that she did not care about what happened there. He also sent an email in 2020 concerning the property, but he said his focus was on the loan owing to his mother. He said that the purpose of his other email was about selling the property, and giving Mrs. Alfred her half was not an admission, because he had no intention of selling it, but rather wanted dialogue about the property and the loan to his mother. Mr. Alfred gave evidence that the title for the disputed property could not be found, and as a result, a lost title application had to be made. He claimed that Mrs. Alfred had hid the title for the property, so he had to obtain a replacement title. She hid the title from him. He signed the relevant document on her behalf as she was overseas and unavailable, and it was their custom to sign for each other. The replacement title was issued on June 4, 2018. Mrs. Alfred denied having any such agreement or custom with the defendant and had never signed any document on his behalf. So she's saying that here he signed the relevant document on her behalf. It was their custom to sign for each other. But then she now is saying, no, that's not so. That they never signed any document. She never signed any document on his behalf. There was no such agreement or custom. Oh boy. She said she was unaware that the defendant, that Mr. Alfred, was applying for a replacement title. She further stated that it was because he had forged her signature. So she's saying he forged her signature and obtained the replacement title, that she had no confidence in the defendant, in Mr. Alfred, proceeding with the sale of the house and dealing with her justly. So she had sought the court's intervention in the division of the matrimonial home. So now she is accusing her husband of forging his title. So you can see how bitter things can really get in the court. Mr. Alfred, in cross-examination, testified that he did not know whether Mrs. Alfred trusted him. In response to the suggestion of Mrs. Alfred trusting him to handle their affair honestly, he stated that they both had an interest and so both had responsibility. He also noted that it was not prudent for him alone to handle all the expenses of the both property, and he would not say they were partners in marriage because the responsibility was not shared. When asked whether Mrs. Alfred had an interest in the property, he responded, quote, "I recognize that she should have shared responsibility. I am not going to say yes exactly, but I am not particularly saying yes to 50%, not sure of what percent," end of quote. The parties lived together after he migrated in December 2009 until 2019, that's 10 years, when they separated. And so you see, they lived together. They went overseas, lived together over there for 10 years, and of course, were together before, for many years before that. When they separated, let me see something here. This is 27 at page 8. They separated in 2019. 27 at page 8. Let's check back something here. They were married in 2000. 2000, the year 2000. Now, they separated in 2019. That's 19 years, and then they separated. 19 years of marriage. All come down to this. Boy. When they separated and the defendant filed a petition for the dissolution of their marriage on the 6th of January 2020. In his divorce petition, Mr. Alfred stated that the date of their separation was December 2017. However, in cross-examination, he stated that they were separated in September to October 2017. Mrs. Alfred, on the other hand, stated that they had been living separately and apart since May 2019, when Mr. Alfred left the matrimonial property. It seemed as if they were trying to live together, but it was just not working out. Alright, submissions. We'll look at submissions in this case in our next video. Remember to subscribe to the channel and to check out the links in the description below.